So if anybody is interested to get the recording, we will have that provided for people. So today's webinar, I am the host. My name is Wendy Aldhamen, and I own Career Elevation. We do dental specific recruiting, where I'll talk a little bit about my business in just a little bit. But we have Norina D'Agostini. I hope I said that right. I think that was right. Right. Okay, good. Which she is a fantastic practice acquisition lawyer, as well as she looks over contracts, which is what we are going to be talking about today. Before you sign, that is all of our conversation today. And I talk with offices all the time about these exact same things. So, Norina, I would love for you to talk a little bit about your business, if you feel that you now is the time you want to do it, or if you want to wait till the end. But I'll have you take it away.
Sure. Okay, thanks everybody who came on. Yeah, this is gonna be a primer on things that you're gonna see in associate agreements as you're kind of considering a position, or maybe you're in one and now you're finally realizing that you need to read it. So just a little bit about myself. I am a merger and acquisitions attorney, which is just a fancy way of saying that I help people buy and sell businesses in the state of Michigan. I primarily help dentists and doctors sell and buy practices. My husband is also a dentist, so I experienced this, in a different capacity as somebody's spouse, having read his agreements when he was working as an associate in multiple offices. So yeah, I don't really couch myself as an employment attorney, but because I tend to see these, whether somebody's asking me about them in a future sense, they're planning, or they might have come to me because they want to buy practice and now they need to actually understand how to get out of the contract or terminate it correctly, or what's their non-compete really say. So definitely this is a future planning type webinar. So hopefully you'll get a good amount of information from what I'm going to share with you. I've been practicing law for almost 13 years. I have 4 little girls, so I have a life outside of this. And so this is kind of my like part-time gig in a sense. I work from home. So please consider use me as a resource, whether you are looking at just your contracts in an associate sense, or you're planning your future for buying a practice. I definitely like to be an open book and give people some initial preliminary information before they actually have to like take the step of, potentially hiring an attorney. So I'm going to get started. This is very informal. I'm not going to bog you down with like the actual case law and reference numbers and all that stuff. I just want to give you a very good overview of kind of what to look out for as you analyze these contracts. And I have to say, as an initial front, consult with an attorney. Some of you might not be in Michigan specific. I practice predominantly in Michigan. Employment law is certainly a very state specific thing. Okay. But if you do have initial questions, please again, feel free to use me as a resource, and I will point you in the direction if I cannot handle it myself. So we'll get started. All right. So the biggest thing that obviously I always get questions about when I'm looking at these agreements is, of course, non-compete agreements. As the legal landscape stands right now, non-compete agreements are very much enforceable. If you kind of were following, the news in the last year, there was this big thing through the Federal Trade Commission where they issued the final rule, which happened, I believe, last spring, which did away with non-competes in certain capacities, we'll say. That has all been kiboshed. Okay, there was a court case in Texas, which came, I believe, in like the end of summer, early fall, and that is essentially where it has died. There is a appeal going through, which will probably go to the Michigan Supreme Court if they decide to hear it. Okay, if they don't decide to hear it, it's just dead. So non-competes are alive. They're definitely state specific. The most strict states, are obviously like California. They hate non-competes, but if you're not in that state and you have a non-compete, the way in which they're analyzed is largely the same, and it's based off a reasonability factor, which is, is it reasonable in scope? meaning, what it actually covers. Are they covering just dentistry? Are they asking that you can't, go open up a grocery store? That would obviously be not really within the scope of what they're trying to protect themselves against. Duration is, how long is it going to be? Is it 2 years or is it in perpetuity? Obviously, in perpetuity is universally not allowed. Or in geography, are we talking a couple miles? Are we talking 50 miles? Generally speaking, in the state of Michigan, I tend to see, non-competes just for an associate anywhere from 1 to 3 years, depending on where the practice is located. If it's in a rural area, it tends to be, the concern is that there's like one doctor kind of serving the whole area. They'll try and just block you out of the whole spot. In, more populated instances, the non-competes are maybe a little bit more limited, to give you the benefit of the reasonableness of allowing you to get another job easily. So the big thing that I see, depending on who you're trying to work for, okay, is in a corporate, let's think like a corporate DSO, or like, like a Dental Expressions, like somebody like that. They'll definitely do multi-location tethers, meaning, your non-compete will not only apply to where you may predominantly work, but it could potentially hit other locations that are under the umbrella of the corporate structure, which again might not necessarily be fair. But what I try to tell people is, like, you don't really want to be the test case, because more likely than not, you're just a regular person, okay? And you don't really want to go to court to like duke this out. So looking into this clause and seeing, okay, is there some level of tethering to the entire corporate makeup and where they're located? Or does it have to do with where I'm predominantly working? Sometimes you'll see them bill into some type of factor, or percentage. Like if you spend 60% of your time in this location, the non-compete will apply there. Obviously, like, in a circumstance where, let's say you're helping somebody out and you're subbing or temping in another location under the corporate structure, did your non-compete now attach there because you work there? So those are like good questions to ask yourself as you're looking through this information. Because obviously your non-compete can get really big really fast if you're working for one of these corporate dental enterprises. Um,
I saw
so that's the big
that
one.
in
Go
the
ahead.
contract just a few days ago, and I was reading it and I was like, oh, this sounds so bad, because it's like this is the office you're going to work for, but it also is tied to these groups. And I was like, we don't even know who these other people are and how many offices are going to acquire and stuff. But it said, which is a nice little like clause in there, that he had to work there for at least 30 days
Right.
in order to do that. So that's a good way to kind of get around it, where you could still work for Aspen, but and they can still tie you to that, but if you're not going to work for all of the locations, then you're out of the non-compete. So that was a really great like little slip in that I was like, oh, thank goodness.
Right. And that's a good point, is you got to really analyze the language to see how fair they're really trying to be. And, big corporate enterprises like Aspen, I mean, they have legal, all right? They have a team that's creating these contracts. Not everybody's like that. I mean, I work with a multitude of clients who create their own DSOs, or like baby DSOs, or like wannabe DSOs, okay, where they might have only, 3 or 4 practices or 2 practices or something in their group, but and they downloaded their contract from ChatGPT, not really looking into the factors I've talked about to actually try to make their non-compete reasonable. And like I said, you don't want to be the test case to like have to duke this out in court to plead your case that this is unfair. So knowing this information can help kind of protect you, in the sense that you could go to a lawyer and you could say, I already know that this doesn't seem legit. Can we negotiate this down? Certainly you could do it on your own, but you might have a little bit more quivers, or arrows in the quiver, if you have a lawyer help you out with it. And if there's more questions about this, like as you're thinking about it, just throw them in the comment section and I'll try and address them at the end of the presentation. Oop, let's go back. Okay, so non-solicits mirror non-competes. They're usually this, they mirror how long they will be in place. And obviously they restrict your ability to, kind of solicit patients and solicit staff, which is, of most paramount importance to whomever you're working for. Um, so the biggest thing is here is how they define solicitation. Sometimes there's carve outs in there, which, take into consideration that you might have personal relationships with some of these people. And, it might say something to the fact that, if you're contacting them outside of a person, a personal in nature type communication, that's where the non-solicitation will come in. The biggest thing that I really have conversations about with this particular clause are people who've left their job, they've started a practice on their own, they have somebody there that, might want to come work for them. And you have to be very careful about this dichotomy because obviously, like somebody comes working for you, it could certainly raise in that, prior, employer's mind that you solicited them. So I always say document, document, document everything that you're doing. Put up ads if you are, if you just started a business. Ensure that, you are getting applicants through ads or through a headhunter, recruiter, because, you are kind of opening that door of questionability if somebody that you worked with jumps ship very quickly after you leave, whether or not you actually solicit them. And in the practical sense, the way this is unfortunately found out would be somebody, saying it, or if the person you end up hiring is a disgruntled individual and they say, oh, hey, I just want to let you know, so and so actually solicited me after the fact. Okay. So that's why you really want to have a good paper trail protecting you if you end up hiring somebody that actually came from, the source of where this non-compete attaches. So let's talk compensation structure. So a couple of different options, there's a salaried option, which is not hugely common. You do see that more and more in a corporate setting now, where they're paying you almost like you are a executive. I think it's more specific to what region of the country you're in to see that. In Michigan, I don't really see that a lot. The biggest compensation structure we see here is definitely based off of production. Collections is pretty rare, meaning collections, of whatever insurance and or patient fees come in, just because there's a huge risk for that, right? Collection compensation structures are usually in a like fee for service practice who's probably not opting into insurance, and they probably have like 99% AR collection rate, so they know that a collection indicator is pretty strong indicator of what's coming in the door. Production in the typical sense is going to be a net production, meaning, after, your insurance, whatever insurance, chargebacks come in for denials, if there's expenses that you are responsible for that are built in your contract, like if you're paying a portion of your lab fee, or anything kind of on that kind of scale, which you really are going to have to read that part of your contract very thoroughly to understand what that could be. It's going to be directly taken out, even before, your check hits you. Um, you know, is the day rate option, which is, you'll see $600 or $700 a day. Again, this is going to be region specific. A lot of the times I see that as a temporary offer, especially initially in your contract. As you kind of gear up, they'll give you like the day rate or production, not a production option, and whatever is greater is what you get. And then it usually goes away like after 60 or 90 days in your contract period, and then you're strictly on the production side of things. Or again, if it's kind of like if you're, in a limited capacity and you're working temporarily, they'll just give you a day rate. But again, that's not something you would see as like a cornerstone of the compensation structure in a long-term employment agreement. So let's go to the next. Okay, so big things right now, and this is like universal in the dental world, is sign-on and retention bonuses. So you'll see these, if you complete your contract for 1 year or 2 years, you get X amount of additional dollars, um, and it'll be paid to you in either like a lump sum or it'll pay over the course of a series of months or something like that. The biggest thing to watch out for this is, of course, the clawback. Okay, which is if you terminate early, you do not fulfill your term. Let's say you have a 2 year employment term, you don't fulfill it, you'll either pay it back dollar for dollar, or you'll pay back some portion of it. And you want to look at, what you're actually paying because, if you have to pay back, let's say you had a $5,000 signing bonus, okay? Do you have to pay it back over a series of months? Do you have to pay it back right away? I mean, everybody, I hope everybody is doing amazingly financially, but, paying back a chunk of cash like that in one fell swoop within, let's say, a 10-day period could really harm you. So understanding what it means. And I think Wendy actually said this, and you can correct me if I'm wrong. Was it like 90% of dentists like don't complete their first job within a certain period? Like you could tell me the statistic.
They stay with their stay. 90% of dentists or any new grads stay at their first office for a year or less.
Right. So definitely look at your jobs as, they're probably not going to be long term. Okay. And or just assume in a default like this might not be the long term one. If it ends up being the long term one, great. So that's probably why it's the best reason to negotiate the contract the way you want it to, so that on the rainy day you're protected. I think my husband had 5 jobs before he bought his practice. Okay. So, you know, turnover is just a nature of this industry. And we're, if they're going to nickel and dime you, like I can promise you, it'll be in every aspect of these compensation type parts of the agreement. Um, and two, how are they paying you? Is it gross or net? If they say they're giving you, like, say they're giving you 10 grand, what does that mean? Like they're giving you 10 grand, and then you're getting taxed on it, or they're actually giving you more. And then with the taxes and all of their expenses included in it, it dials down to 10 grand. So just understand what the benefit really is. And I would say like all of these questions that all the things that I'm talking about are legitimate questions and points to bring up during the course of talking about your contract. If you're meeting potential employers and they're not open to talking about this, it's probably a pretty big red flag. They're obviously crafting these contracts to protect them. The expectation is that you should be able to comment on them in order to protect you. And a lot of them just have no idea too. Like I said, people will go and make these contracts online, have never read them, have no idea. I had a guy call me one time. He wanted to help him with a contract because his associate was leaving. He thought he had some long notice period. He thought he had a penalty built in if people don't terminate before the term. He had none of that. So you bringing up actually could be potentially helpful to them. So definitely don't shy away from talking about all of these things that we're covering today. Okay, so termination is a big one because it's going to be, potentially what you're in, and usually it's kind of this notice period waiting time frame. So typically the default, depending again on which state you're in, if you're at will state, Michigan is an at will state. The default is that you can just terminate for any reason or no reason. Now contracts change that, right? You have the freedom to contract in almost every state. So you can change those lines depending on what your contract says. And normally, an employer is going to put in there a without cause for certain, for pretty much like all circumstances that fall outside of a for cause termination, which is going to be like if you show up inebriated to work, or if you if you get charged with a crime or if you lose your dental license, those are going to be like automatic terminations where if that happened, you could just be cut. There's no notice, you're out. Okay. That's for the employer side. The other way is without cause. Like basically, I just don't need you anymore. So I got to cut you. And within the context of that, there's usually a notice provision attached to it. Okay. Maybe it's 30 days, maybe it's 60 days. Okay. Where they're saying, Dr. So-and-so, it's been great, but we're going to cut ties. Okay. And this is your formal, indication that you're within your notice period. Well, whatever. So you have that amount of time left in your contract to work. It goes both ways, right? So if you decide to terminate your contract without cause, there's usually on the employee side a pretty long notice period. I normally see 60 to 90 days. If it's corporate level, a corporate entity, like 90 days almost across the board. Okay. And you better stay there every single day unless they come to you and say, great news, we found a replacement, you're out. If they don't tell you that, I can promise you, and I have friends that have been sued, that they will come after you for a violation of that term. A lot of these corporate heads build into these agreements penalties associated with every single day that you failed to live up to your obligation. It could be a liquidated damages clause, meaning there's a dollar amount associated with the day in which you fail. So let's say your notice period is 90 days. You work for 60 and you say like, I'm out. And then the liquidated damages clause says, okay, every day that you're in violation, it's $500. So it's 30 times 500 pay up. So, when you're evaluating the most ardent entities that are going to pursue these are always the entities with deep pockets. Okay. You might have a little bit of negotiating room with like, Dr. So-and-so who's owned his practice for 60 years and he really doesn't want to sue anybody. You might be able to kind of navigate through this without, even though you're technically in violation, but truly you don't want to be in that position at all. So understanding what you're kind of signing up for, whether there's penalties involved, if you breach the specific clause, and if you could potentially negotiate a lot of that down so that, you're planning for a rainy day. The opposite of that, which universally I do not see this in contracts from employers, is you can negotiate your own termination for cause, okay? Your own immediate termination. So a lot of times I'll build into these agreements is what happens if they stop paying you and you haven't gotten a paycheck in 20 days? Okay. That's first of all would be awful, right? But you could build it in your contract. You're not paying me. I provide you notice that you're not paying me. If you don't cure this within 7 business days, I can immediately cut ties from you and I'm out from this entire contract. Okay. So you can build it in to protect yourself. What happens if the guy running the practice is like a crook? Okay. And he's committing insurance fraud. You could provide them notice that, hey, I noticed this things going on, provide your cure, and now you have a basis to terminate. Okay. So definitely view it as a two-way street. And that will absolutely give you those escape hatches that, in the worst case scenario that you needed to get out if you're just in an absolutely terrible working environment. That now you have a list that you can work off to potentially protect you, or at a minimum, give you some colorable argument that they just don't want to deal with to actually try and pursue you legally. Okay. All right, we went through notice. Let's see. Okay, benefits. This is going to be kind of the gambit of the typical stuff you see, whether it's healthcare, CE reimbursement, which is starting to kind of gain a little bit more traction in a lot of employment agreements I see, even like uniform, like per diem, like you'll get a, $200 a year if you want to spend on uniforms, paid time off, which depending on your state, might be mandatory. So Michigan just went through a change in the law where we have mandatory PTO, and it's based off of some factors, but it is now a part of the landscape. Unfortunately, what's going to happen is if they're going to end up rolling, if you have vacation days, they're end up going to be taking from vacation days to cover this. I mean, that's what's going to happen. But depending on your state, you might have state a statutory right to pay time off. Malpractice coverage, a lot of times, unless it's a large corporation, you cover your own malpractice, and also your tail coverage, which is, if you don't know what that is, if you have a claims made policy, okay, which means when you have the policy in place, and let's say somebody comes to sue you for whatever, that policy will kick in. At the end of that policy, like it's done. So if Mrs. So-and-so says, in 1997, you malpracticed me and you don't have a policy in place, or that specific policy expired, you don't have coverage. So you need to get a tail, okay, which is to fill the gap for the time period when that claims made policy was in place, okay? So, and again, this only applies to claims made policies. You might have an occurrence-based policy, which is whenever, and they're more expensive. So if you paid the policy for 10 years, let's say, and somebody comes after it's expired, you still get the benefit of them indemnifying you or protecting you in the legal sense and fighting your battle, which is not the same as a claims made policy. So normally you will have to pay for your tail policy. Just understand that when you are reading through this particular section in the agreement. I brought up the 1099, meaning if you're an independent contractor here, because obviously if you're an independent contractor, you don't get any of these benefits. Not obviously, I've definitely seen my color of interesting agreements. But I will say just universally, dentists for the most part, and other, doctors or so-and-so on the same level, should be W-2'd. There is risk to you if they 1099 you. Obviously, it's not as great as if you are the owner, because they're going to have the deep pockets. They're not paying all the taxes associated with W-2ing, and that's a huge, major problem for the federal government and state government when it comes to unemployment benefits. But you still have risk. You could still be audited. You could still be required to redo your taxes and pay any penalties and back taxes associated with that audit. You could be audited by the state unemployment and benefits office in your state. You just don't want to deal with it. So if you go in, and this is more common with, we'll say the older generation of doctors, who 1099 independent contractor everybody improperly. If they say, well, we just want to do it that way, I would strongly insist that you do a W-2, just in the 1% chance that guy gets audited, which totally can happen because I definitely see dentist books all the time. And they start poking into, well, how is this person being paid and that sort of thing. So W-2 is the way to go just to protect yourself. Okay, let's see. Okay, additional kind of restrictions that you might see in these agreements are IP ownership, which is just intellectual property, and this is pretty expansive. Okay, so this is relevant today because many young dentists are using social media, right, to promote their work, to be, kind of like promote their image and likeness, and kind of celebritize themselves so that they get patients, which is totally great and the lay of the land. There could be in these agreements some language that essentially says whatever you create during the course of your time here, and we're not just talking like inventions, but certainly you see those too. That belongs to the practice. You might see this more in a corporate sense, okay? Which means that, if you have a big following online, and you have all this content online and you were creating it during the course of this contract, I mean, you could be jeopardizing that that of what you've created. So just be aware of it. It's obviously on the rarer side of what to worry about, but given how things are going in terms of technology and social media, it's something that you should certainly be aware of. And you know, if you end up blowing up and being, you know, the next best thing in the dental world, you know, that means you're a great target to come after. So let's go to the next. So dispute resolution is like, how are we going to deal with this if people got a sue? All right. So there's two ways these are built. There's arbitration or mediation arbitration, which is like a separate venue outside of the typical court system that you see, which is, you know, what you see on TV or the West Wing. Okay. If people even watch the West Wing anymore, which probably aged me. And so that means that, you know, you're basically foregoing the typical court system. You're saying, I'm willing to mediate these or arbitrate these issues outside of that. The old reason why people did this is because they think it's faster and they think it's cheaper. Tends to be faster, but it does not mean it tends to be cheaper. It's selected to give really the employer the benefit of you know, getting it away from like a jury, which could obviously look really bad for them depending on what it is. Potentially expediting the process. Usually they want it to be unappealable, meaning you can't take that judgment, go to a regular court and try and appeal it up through the court system. Like just think default, like how we go up through the Supreme Court. Obviously that's a large scale, but we mirror that process in every state in our union. So the biggest thing here is reading what law would apply. And I don't expect you to know that, but there are certain jurisdictions that are friendlier to, let's say, plaintiffs, which are people who are bringing the actual claim, versus defendants are people who are defending themselves. So depending on who you are, some jurisdictions are more friendly or not. But the venue is a big thing. So if you're just getting it from some guy that's had a practice for 50 years, it's probably going to be, the venue is going to be where his practice is situated. But if it's a corporate contract, they're probably going to use Delaware law, and it might be in the headquarters of where the corporation is situated. So let's say it's an Illinois company, and you work in Michigan, and now you have to go to Illinois to defend this lawsuit. So just have to understand, like, that's kind of how it can be an intimidating factor to not, number one, wanting to screw up under these contracts, but the kind of cost prohibitive aspect of, if things really went south, like, what am I actually looking at? Okay. This is the last thing I'll cover, which is really for people who maybe be in a position where they are maybe they're working for somebody that they would like to take the practice over with, or let's say they're looking at a multi-location practice, and they're promising you, in that multi-location sense, that you would get a piece of wherever you're working, which happens, all the time. I read this, not as common, but it definitely happens. So sometimes what they'll do in employment agreements is they'll kind of bake it into the agreement of like how you can get a piece of the company. And it's not always written in a way that you actually understand that you might not actually be getting anything. You might just be getting a promise to contract, okay, which is fully discretionary to the employer, like that, puts in all this ability to basically put the kibosh to it, or it's not really what you think it is. Okay. So there's kind of like three areas of this specific category. Okay. There's profit sharing. Okay. There's a true equity. And then there's we'll call it phantom shares, which has a specific meaning, but it's kind of the easiest way to describe this. Okay. Profit sharing is not ownership. Okay. So if they are promising you equity and it's really profit sharing, what they're basically saying is like almost like a bonus system. Okay. If we hit a certain target, you're going to get a cut of that target. In it, and it's going to be taxed as income. Okay. Um, Not equity. There's or phantom shares, which is also not equity. It allows you to reap the benefits of, let's say, a sale of the business. And so let's say they give you like, 5% phantom shares and the company sells, for $1 million. You would be able to take a 5% of that $1 million at the payout. But you'd have no voting rights in the company. You would unlikely have any ability to get distributions, which are dollars given to equity holders after all expenses have been paid, as essentially a piece of the profit of the business. So you definitely have those. A lot of those are called like equity in name only, okay, because they're not equity. And then there's true equity, which is, let's say you have an LLC. It's you have an operating agreement, and they're amending that operating agreement, and they're making you a member, or they're amending a bylaws or creating bylaws, and they're making you a shareholder. So on paper, it's showing that you have, shareholder rights. You can vote or not vote, depending on obviously how big this company is, right? Um, and you would have rights to distribution. You'd have kind of all of these typical things you get as in a true owner sense. So you kind of need to be aware of that, and a lot of times even dentists who are talking about these things don't even really understand what they're like. They might have something in their mind and think that's what they're saying to you, and then they like write it down, and it's really not even close to what they think, and then you're reading it, and it's going to be like two ships passing in the night. So if you are in that position and you actually want to buy in, you definitely want to create very specific contract language in your employment agreement to allow you to trigger your ability to buy in, which definitely I would not chat GPT that. I would do that with a professional. If you're, especially for, I've worked with plenty of people who have bought into, really successful practices, and that's what they want to do, and it could be a great opportunity. But if you are not in sync with that owner, you're talking about just landing flat-faced immediately, which could totally just kind of screw up the trajectory of the future. And that's kind of the overarching theme of this webinar, okay, is plan for your future, because where you are today is more likely than not where you want to be, in 3 years, in 5 years, in 10 years. So, this is every facet of what we talked about, whether it's the non-competes or the terminations or, the compensation structure, just understanding all of this. And once you do understand it, you'll be a better dentist in the sense that you know how to do it yourself when you might be in this position. So does anyone, I just want to make sure I didn't get any chat questions.
Yvonne had sent a few and had taken some away, but she just said literally ChatGPT cites cases that don't even exist. And I know you and I were talking about that yesterday, of like phantom language and phantom cases and stuff. So so interesting that it can do that. But I
Yeah,
have
so
some questions. So when you're ready, I'm ready for you. If
yeah,
nobody
no,
else has any questions.
I finished yeah, I did it. Okay, I did all the things I was gonna do.
Good.
Okay. So yeah, why don't we do questions, because I want to make sure we have plenty of time to get everybody's answer or questions answered.
Okay. I will Well, I'll say my thank you. We'll go to the next slide, as I know what the slides look like, and then we'll sit on your slide instead of on mine. So,
Okay.
thank you all for joining. We'll go through questions here in just a hot second. And if you weren't here necessarily in the beginning, I am the owner of Career Elevation. We do dental specific recruiting. We recruit for not only dentists, but for anybody within the dental office or dental space. So if your office is looking for an assistant or an associate or a manager, I can help you with that. And I also really enjoy webinars like this. So I'm the host of the webinar today, and I had asked Norina, like, hey, I think you could probably help a lot of the dentists that I talk with. Would you be willing to do a webinar? Which this link, if you are able to scan it on your phone, otherwise you can just go to my website and it's under the little hamburger that is website/courses. So you're welcome to find any of the courses there or the webinars there, and you can click onto it. If you need any help, obviously here's my phone number. You can call or text. Same with my email. If you can hit to the next slide, these are the next few webinars that I have. I have one scheduled tomorrow. So if you are a hiring manager or owner, this is going to be for you. And then I have the next one that I think would really relate, the next two that would really relate to this is the May 13th. So find your perfect dental office. And that's a lot of these kind of questions. Like I'm telling people, basically your overarching theme for this is if something feels shady, it probably is. And those are the kind of questions that we talk about so we can uncover if that's shady. And that webinar on May 13th is really for truly it could be for the office, the hiring office, or for the candidate. And then on May 28th, this also goes along with the malpractice and disability insurance that you were talking about a little bit earlier. So if anybody needs that or has questions, Nick is a really great resource for that. So and then again, this QR code is for the list of webinars, so you can get signed up if you want to. Okay, now we can sit on your slide. You can hit the next one.
All right, so that's me. So yeah, please feel free to text me or email me if you have questions. I try to offer associates and really anybody like a very affordable, I call it a review and consult, just so that you can understand your contract, whether you're an employee or an employer, right? And it's just a flat fee. It's capped at 4 hours. And because I understand just from being, married to somebody who was a young associate that, you guys are not really cashing in, right? Like you have loans and you have responsibilities. So I want to make sure that if you are feeling very uncomfortable about a potential contract that you're about to enter into, that you could talk to somebody and it's not going to destroy your bank account. I have been asked questions about ChatGPT. I use ChatGPT as a legal tool. So I think it is a extraordinary tool. I would not solely rely on it as your legal counsel because as somebody who reviews contracts every single day of my life, there are inconsistencies in the program. So if you're viewing things in isolation through ChatGPT, it might be doing a very good job of telling you what it means, but it might not be doing a very good job of telling you what it means in the context of the entire contract. But it is getting better. So maybe one day it'll make me obsolete, and it is what it is. But for now, I would talk to a human being if there's some nuances in there, especially if you're looking to work in a corporate setting, which their contracts tend to be very long and very jargony. So please, I encourage you to do that. And yeah, any questions? I'm game.
Yeah. Molly sent me a direct message and asked if we will share the slides. I told her that we are going to share the recording. If you're okay with sharing the slides, I can do
Yeah,
that too.
yeah, 100%.
Um, I also wanted to just take a note. I had taken a few little points that I wanted to talk about, and how earlier you had said that sometimes the office doesn't necessarily pay attention to all of the details in the contract. Sometimes they just like fill in your name and just kind of go about it. I talk to so many dentists that don't know their notice time and also their non-compete. And I think those are the two most important things superficially. I mean, obviously there's like a ton of other things, but when you're looking for another job, those are the two things that you should probably know going into it. Or trying to exit, I should say, when you're trying to interview for other places. Those are going to be probably the two main questions that are asked. Because obviously the office that you're going to be working with, if it's within that non-compete zone, I think that there's so many offices that are like, well, we're gonna fight that. Like just don't just read it. So just kind of another little thing that I see people all the time, not having any idea about what that looks like. But I'm just curious, you had said sometimes that in Michigan just passed the PTO state satisfactory, I think you said.
Yeah.
Do you know what will happen with contracts for associates if they are paid on a percentage of collections or production for that, or is that only going to be for people who are a daily salary? Does that make
That's a
sense?
good question. So I haven't read the statute like super in
Okay.
depth to understand the carve outs. So I don't know the answer off the top of my head as far as how they're calculating it. I've read some kind of just blurbs on like how people are going to try covering themselves because there are so many places that offer like paid vacation. Just plucking it from paid vacation to say, look, we have paid time off, or sick leave, or other things that they give as benefit. How strict they're going to actually get into the details statutorily wise, unfortunately, will probably be based off of lawsuits.
Okay. Um, Interesting. And then I don't often find offices a ton of times having PTO for their associates. What do you often see with PTO in that sense? Is it just that they're allowed to take it, or do they get a daily rate while they're gone?
Yeah, so most of the time for dentists, I do not see
Okay.
outside of like a larger corporation uh, giving paid time off to them. It's normally just unpaid leave for whatever amount of time, 2 or 3 weeks or something like that, and they're not getting anything. Again, that is depends if it's a just a regular person, regular guy owns one practice versus a big corporate structure, which I definitely read corporate docs where they give them paid time off for maybe 10 days or something like that. And it depends. I've seen them where it's a day rate. They'll get whatever it is, or they'll do like an average of their collections or something like that from some time frame as what they would get paid. It would be more normal, I would say, to see some type of cap.
Awesome. The other point there or question that I had was when you were talking about the promise to contract for buy-in,
Mhm.
um, if they are working on buy-in and I usually do the placements and I don't often see how the contracts will evolve once they're going to purchase the practice. So I'm a little bit naive to this, but what happens if that dentist that they're trying to buy in from goes bankrupt? And like just the contract is just dissolved.
Yeah,
Yeah.
yeah. So unfortunately, and this has happened, if the target will say it essentially dissolves or goes bankrupt or whatever, I mean, at that point, even though you have technically an enforceable contract, do you really want to enforce it? There's no, I mean, if a dental, so the most bankruptcy proof practice is a dental practice. Okay. They go bankrupt. I think the lowest in any industry, hands down. That's why you guys, when you decide to potentially buy a practice, like you get agreed to on loans, approved for loans, like 99.9% of the time. Okay. So if a practice is going under, I can assure you that guy pulled every single loan out this side of the Mississippi. And so there would be no reason to, like, nobody would be enforcing any contracts because you would essentially have a judgment proof um, individual on the end of that claim.
Interesting. I mean, I've heard that bankruptcies don't happen often in dentistry, and I know that just from being in dental for 15 years. But I didn't realize it was the least bankruptcy. I'll be to put that into it.
Yeah, it's probably, if it's not the lowest, it's probably in the top three.
Yeah.
because it's just is a pretty good business model. I mean, there's a reason why DSOs exist, because they've figured out how to monetize them.
Good. Those are all the questions that I had. I think I was thinking about a lot of questions before we got into it today, and you hit on all of the things that I wanted to like ask about or talk about. So that's fantastic. If I know you had mentioned if anybody has any questions, they can send me a message, and I urge everybody to take a screenshot of this so that you're able to chat with her again, or I will be sending the recording as well. So you can, and I'll have Norina's information in that email to send out to anybody who is interested. So.
And I'll just add one more thing that I forgot to mention on the compensation slide. One thing that I do see a lot of, okay, just so you understand this when you're doing this review, is a lot of places, whether it's corporate or it's just a regular guy, will try and cut you off on what you get in your last paycheck based off of the date of termination. So just keep that in mind, okay? Like kind of goes to the clawback type thing, like they'll write something in there that says like you'll get upon the date of termination, depending on the payroll cycle, like that is all you'll get. That'll be your last paycheck, and you're not entitled to anything that comes in after that date. Meaning, if you're an insurance heavy practice, okay, where you have insurance companies, depending on who it is, right? Who's got 30, 60-day cycle turnover and payment. I mean, you could be forfeiting a ton of cash that would be coming to you within a 30 to 60-day cycle after you terminate. So just be very aware of that when you are reading through that termination section.
That's a really good point too. And I wonder if there's any language that you see in contracts, or if it's just somebody that's going to be unethical and they're just going to do it because they're turds. But is there anything that you might see in language in regards to that says that they have to do their due diligence to actually file to the insurance company? Because they could just hold the claims depending on what insurance company, because some of them you can submit after, or you have to submit within 6 months, but an office is probably not going to pay you after 30 days or 60 days or something like that. Is there any language that you see, or do you just kind of hope that they're going to be ethical and actually file when they're supposed to?
Yeah, so you definitely can push back on that to require like a reporting obligation that they provide you like the EOBs showing that they've been submitted. I mean, obviously at this point, okay, if you think they're like withholding insurance payments in order to cheat you out of money, like we got some serious problems in this practice and like nobody should work for them. But you can absolutely build it into your agreement that you would like a report, essentially a reporting obligation, that if you requested of them some type of report, either the EOBs or some even like depending on the software they use, like EagleSoft or Dentrix or whatever, some type of day sheet or payment, a proof of payment that they would be obligated to provide it to you, within 10 days of your termination or something like that.
One other thing I did think of too that I often get with questions is the percentage of lab bill. I think that goes literally from 0% to like the 30-ish% where people usually are paid, and then 100% that has to be paid. And then one other question of collections. But is there anything that you typically see? I don't usually give a range because it's zero to 100% for what the associate dentist is going to have to pay on their lab.
So yeah, it's definitely so if it's like whenever it's like a nicer lady or lad, okay, like who just are trying to like phase out, usually the lab fee is always zero.
Uh-huh.
It's just from experience. If it's, a typical, dental setting, corporate setting, or, let's say it's a younger owner or something like that, and they're obviously really trying to keep an eye on their overhead, yeah, the range from what you said is pretty normal. I would definitely see some level of the office taking on the lab fee. I would say 100% is usually pretty rare in a general dentistry setting. If it's like a specialty, which might not even be an employment agreement. That could definitely be in a 1099 sense. If it's like situational where somebody's coming in, let's say, and placing implants or something like that, then yeah, you can see 100% a lab. But if it's like a true associate agreement, I'm rare to see a 100% lab cost on an associate. So yeah, so that's kind of my feeling and experience about it is some coverage is normal, whether it's 30 or 50. Do you have an additional part of that question?
It was just a secondary question that I didn't want to figure out.
Okay.
When sometimes I will talk to associates, I'll talk to offices, and when I'm trying to place somebody, we'll talk about what their percentage of collections is.
Yeah.
And I wonder if there's any language that an associate, and this might be too nitpicky, but also like maybe this is the only thing in the contract that might be needed to be edited, for example. But is there anything that you've ever put into a contract or that you've ever seen to say like, hey, I'm the associate, but I would like the office to make sure that they maintain above 85% of collections or above 90% of collections. Otherwise, I get like my percentage of collections gets automatically switched to production. You know, if the office manager leaves or something along those lines. Is that something that you've ever seen in a contract?
I've never seen that in a contract. I mean, that doesn't mean it can't be in a contract. And more likely, if that is in a contract, it's probably because whoever they're hiring is probably a little more savvy, maybe a little bit more experienced. Maybe the dental practice is having problems and they're kind of desperate, and you're definitely in the driver's seat for negotiating. Um, and you're able to kind of come up with that, which isn't a bad kind of like breakdown, in terms of switching based off of how well they're doing collection wise. Because certainly if they're, and again, they're probably not going to show you their books, but certainly if their AR is lagging, that obviously would be, I've seen in rare occasions practices that have like 200 or $300,000 in uncollected accounts receivable. So that's probably going to be a very unique circumstance if somebody's trying to actually negotiate that specific term.
Um, I'm sad to say I have seen 600 plus thousand, which is what the office had made in a year. It was a very small practice. So very, very interesting situations that I've seen that I've walked into. So that's great. Well, I'm glad that you haven't seen that. Hopefully that's not something that needs to be enforced all too often and things like that, or maybe just people don't necessarily think about it. But yeah, those are all the questions that I had. It doesn't look like there's any other questions that we're rolling through, and at least on my end. So fantastic. I really appreciate the opportunity for you to talk for us here at Career Elevation today, and hopefully this is going to be able to help hopefully a lot of associates now and in the future.
Yeah, absolutely happy to do it. Appreciate you letting me on. And again, I consider me an open book. I'm not a gatekeeper. So any questions, just shoot them my way. And if I can help, I will.
Awesome. Well, thanks so much, and I look forward to the opportunity to chat with you again soon.
All right. Thank you, everybody. I appreciate your time.
Thanks. Bye.
Bye.